National Labor Relations Act of 1935. Transcript of National Labor Relations Act, as amended since 1935. An act to diminish the causes of labor disputes burdening or obstructing interstate and foreign commerce, to create a National Labor Relations Board, and for other purposes. Findings and policies. Section 1. The denial by some employers of the right of employees to organize and the refusal by some employers to accept the procedure of collective bargaining lead to strikes and other forms of industrial strife or unrest, which have the intent or the necessary effect of burdening or obstructing commerce by a. impairing the efficiency, safety, or operation of the instrumentalities of commerce, b. occurring in the current of commerce, c. materially affecting, restraining, or controlling the flow of raw materials, or manufactured or processed goods from or into the channels of commerce, or the prices of such materials or goods in commerce, or d. causing diminution of employment and wages in such volume as substantially to impair or disrupt the market for goods flowing from or into the channels of commerce. The inequality of bargaining power between employees who do not possess full freedom of association or actual liberty of contract and employers who are organized in the corporate or other forms of ownership association substantially burdens and affects the flow of commerce, and tends to aggravate recurrent business depressions by depressing wage rates and the purchasing power of wage earners in industry, and by preventing the stabilization of competitive wage rates and working conditions within and between industries. Experience has proved that protection by law of the right of employees to organize and bargain collectively safeguards commerce from injury, impairment, or interruption, and promotes the flow of commerce by removing certain recognized sources of industrial strife and unrest, by encouraging practices fundamental to the friendly adjustment of industrial disputes arising out of differences as to wages, hours, or other working conditions, and by restoring equality of bargaining power between employers and employees. Experience has further demonstrated that certain practices by some labor organizations, their officers, and members have the intent or the necessary effect of burdening or obstructing commerce by preventing the free flow of goods in such commerce through strikes and other forms of industrial unrest, or through concerted activities which impair the interest of the public in the free flow of such commerce. The elimination of such practices is a necessary condition to the assurance of the rights herein guaranteed. It is declared to be the policy of the United States to eliminate the causes of certain substantial obstructions to the free flow of commerce, and to mitigate and eliminate these obstructions when they have occurred by encouraging the practice and procedure of collective bargaining, and by protecting the exercise by workers of full freedom of association, self-organization, and designation of representatives of their own choosing, for the purpose of negotiating the terms and conditions of their employment, or other mutual aid or protection. Definitions. Section 2. When used in this act. 1. The term person includes one or more individuals, labor organizations, partnerships, associations, corporations, legal representatives, trustees in cases under Title 11 of the United States Code, or receivers. 2. The term employer includes any person acting as an agent of an employer, directly or indirectly, but shall not include the United States, or any wholly owned government corporation, or any Federal Reserve Bank, or any state or political subdivision thereof, or any person subject to the Railway Labor Act, as amended from time to time, or any labor organization, other than, when acting as an employer, or anyone acting in the capacity of officer or agent of such labor organization. Public Law 93-360, 1a, July 26, 1974, 88 Statute 395, deleted the phrase, or any corporation or association operating a hospital, if no part of the net earnings inures to the benefit of any private shareholder or individual from the definition of employer. 3. The term employee shall include any employee, and shall not be limited to the employees of a particular employer, unless the Act explicitly states otherwise, and shall include any individual whose work has ceased as a consequence of, or in connection with, any current labor dispute, or because of any unfair labor practice, and who has not obtained any other regular and substantially equivalent employment, but shall not include any individual employed as an agricultural laborer, or in the domestic service of any family or person at his home, or any individual employed by his parent or spouse, or any individual having the status of an independent contractor, or any individual employed as a supervisor, or any individual employed by an employer subject to the Railway Labor Act, as amended from time to time, or by any other person who is not an employer as herein defined. 4. The term representatives includes any individual or labor organization. 5. The term labor organization means any organization of any kind, or any agency or employee representation committee or plan, in which employees participate, and which exists for the purpose, in whole or in part, of dealing with employers concerning grievances, labor disputes, wages, rates of pay, hours of employment, or conditions of work. 6. The term commerce means trade, traffic, commerce, transportation, or communication among the several states, or between the District of Columbia, or any territory of the United States, and any state, or other territory, or between any foreign country, and any state, territory, or the District of Columbia, or within the District of Columbia, or any territory, or between points in the same state, but through any other state, or any territory, or the District of Columbia, or any foreign country. 7. The term affecting commerce means in commerce, or burdening, or obstructing commerce, or the free flow of commerce, or having led, or tending to lead, to a labor dispute burdening, or obstructing commerce, or the free flow of commerce. 8. The term unfair labor practice means any unfair labor practice listed in Section 8. 9. The term labor dispute includes any controversy concerning terms, tenure, or conditions of employment, or concerning the association or representation of persons in negotiating, fixing, maintaining, changing, or seeking to arrange terms or conditions of employment, regardless of whether the disputants stand in the proximate relation of employer and employee. 10. The term National Labor Relations Board means the National Labor Relations Board provided for in Section 3 of this Act. 11. The term supervisor means any individual having authority, in the interest of the employer, to hire, transfer, suspend, lay off, recall, promote, discharge, assign, reward, or discipline other employees, or responsibly to direct them, or to adjust their grievances, or effectively to recommend such action, if in connection with the foregoing the exercise of such authority is not of a merely routine or clerical nature, but requires the use of independent judgment. 12. The term professional employee means a. Any employee engaged in work, 1. Predominantly intellectual and varied in character, as opposed to routine mental, manual, mechanical, or physical work. 2. Involving the consistent exercise of discretion and judgment in its performance. 3. Of such a character that the output produced, or the result accomplished, cannot be standardized in relation to a given period of time. 4. Requiring knowledge of an advanced type in a field of science, or learning customarily acquired by a prolonged course of specialized intellectual instruction and study in an institution of higher learning or a hospital, as distinguished from a general academic education, or from an apprenticeship, or from training in the performance of routine mental, manual, or physical processes. Or b. Any employee who, 1. Has completed the courses of specialized intellectual instruction and study described in Clause 4 of Paragraph A, and 2. Is performing related work under the supervision of a professional person, to qualify himself to become a professional employee, as defined in Paragraph A. 13, in determining whether any person is acting as an agent of another person, so as to make such other person responsible for his acts. The question of whether the specific acts performed were actually authorized, or subsequently ratified, shall not be controlling. 14. The term healthcare institution shall include any hospital, convalescent hospital, health maintenance organization, health clinic, nursing home, extended care facility, or other institution devoted to the care of sick, infirm, or aged person.